Good morning. I'm State Senator Joe Uecker, currently the chair of the Joint Committee on Agency Rule Review, and we're here to introduce a couple of bills that we feel are going to help improve the ability of the legislature to legislate and to keep Ohio running smoothly. The JCARR was created back in 1977 by the Ohio General Assembly, and its primary function is to review proposed, new, and existing and amended and rescinded rules from the over 110 or so state agencies to ensure that they do not exceed their rulemaking authority that was granted them by the General Assembly. And we have, I think, 6 prongs that we review, that JCARR staff reviews. And so we're here today to speak about the legislation. I'm here with co-chairman of the JCARR State Representative Mike Duffey, and we'll let Mike talk a little bit about the policy aspect of the legislation, but I'd also like to take time to introduce as well the JCARR staff is also here today, and I'll recognize Director Larry Wolpert in the back, and Larry's here to give us some guidance along the way as well, perhaps. The legislation started probably about a year and a half ago. There was a number of reasons why the issues have come up where perhaps we need to strengthen it and to maybe make some changes to the technical aspects of the committee. And we want to thank many members, both members within the committee and from the outside who have been part of the process. And I'll let the Representative Duffey talk about some of that. Representative?
Thank you, Mr. Chairman. Thank you all for being here. Really this started with a couple things. JCARR staff noticed procedural improvements that we could make, things that make the process go a little bit more smoothly, a little more quickly. The Ohio Chamber of Commerce has a small business council. The small business council identified some frustrations with the rulemaking process, said, let's improve it. How can we make this better for businesses? How can we make it so people know what rules actually affect them, know what the rules mean, are able to find all the information exactly pertaining to them, whether it's a policy or a rule. It's not always contained in the 4 corners of the document of a rule. So one of the issues that this bill addresses, among many others, and Director Wolpert, you'll be coming up to speak a little bit to the bill, will be policy making in lieu of rulemaking. Now, if you look at the revised code, I'm going to drop some citations on you for a moment. 119.01 Administrative Procedure Definitions says that a rule means any rule, regulation, or standard having a general uniform operation, adopted, promulgated, and enforced by any agency that affects private rights and does not include guidelines consistent with 3301.0714, and that exception is for EMIS, the Educational Management Information Systems. Broadly speaking, the definition of a rule is something that affects private rights. It is a standard promulgated by an agency. And what that triggers is a pretty robust review process. There are public hearings that have to happen, there's public notice that must happen in a certain period of time. And in 119.02, immediately after that section, the very second subsection of that chapter says, if it doesn't go through the public process, it's invalidated automatically, which means somebody could go to court and could file a lawsuit to say that that rule has no effective law. Now, what happens if the state agency does a policy that doesn't go through public hearings? First of all, an affected business or regulated entity does not have notice that that issue exists. They don't show up at a hearing. They don't comment on it. The agency doesn't consider their objections. The rule doesn't get better for business in Ohio. So we really need to make sure that all rules are formally filed as rules and not done as policy. That's one of the fundamental things that this bill will do. In addition to that, I want to emphasize that rules are state law. Statutes are more authoritative than rules, but rules have effect. They have the ability to make or break businesses in the state of Ohio. So we need to make sure that that process is public and that it's fair. While most agencies are good, humans can make mistakes. It is possible for an agency to make a policy that hurts a business in Ohio. That's one of the reasons why CSI was created under the leadership of Governor Casey and Lieutenant Governor Mary Taylor. And we think that process has done a lot to make the the state of Ohio more welcoming to business, but we can go a little bit further. JCARR right now cannot really review in the middle of a 5-year review process. So if there's an unforeseen impact on the business, we can't really do anything about it. That's one major issue with the current system right now. Director, if you'd like to, I think you can summarize a few more provisions in the bill. I want to hit just one or two more. Right now, it's possible for a state agency to actually not promulgate rules, and there's very little that JCARR can do about that. So one of the things that we're going to be able to do, if this bill passes, in addition to if a rule is done as a policy, we can ask the agency to come before JCARR, we can ask them why they didn't file it as a rule. We can formally ask them to file it as a rule. We can also ask them why they're not filing rules that they're statutorily required to file. People will be able, agencies will be required to periodically, after a new gubernatorial administration starts, self-examine their existing rules and policies to determine whether or not they should have been formally done in rulemaking. People may petition the agency to write rules if they've been party to an adjudication. People may have a cause of action in court and receive court costs and attorney's fees if they're negatively affected. The auditor of the state, if they discover a rule that should have gone through rulemaking and only was a policy, they will be able to flag that for JCARR review. When a rule incorporates a document by reference, for example, a manufacturer's manual as it relates to safety standards, that agency must include a dated citation for that document. They may not automatically include future versions of that document that do not go through JCARR review. When a rule incorporates a document by reference, people are going to have to go and find that document. Currently, that document could be something that could be expensive. It could be a manual that costs $500, and somebody has to go out and get a copy of that. We're going to make sure that that's available at no cost to the affected regulated parties who are requesting that document. We're going to do a variety of technical changes. We're going to make it easier to furnish JCARR with reference documentation if it's readily available, so the agency doesn't have to copy extra documents and put them into the filings. And we're going to add a 7th prong to JCARR invalidation that allows the committee to initiate an invalidation recommendation if a rule imposes a fee that is not reasonable or fairly related to the cost incurred by the agency. For example, if an agency attempted to charge fees that resulted in a profit to the agency or vastly more revenue than it actually costed the district. Adverse impact, the definition, which is currently the definition that triggers a CSI review, is going to be expanded. Right now, currently, if a rule charges a new fee to a regulated entity, that direct charge triggers an adverse impact. However, if a rule was to destroy a business in the state of Ohio or negatively hurt the revenues of that business, but did not impose a direct fee on the business currently, it would not be subject to an adverse impact review by CSI. We are going to expand it to be if it has a negative impact on revenues or increases the expense of the business. If enacted, we think that this will help many businesses, and I know that with us today is the director of JCARR, and they'll be able to speak in much more detail about some of the things that our staff has encountered over the past several years. And then also with us will be a member of the Ohio Chamber of Commerce who can speak to his specific example, Mr. Tom Secor.